Please join the California Teachers Empowerment Network and the Association of American Educators in watching a lively discussion of the Friedrichs and Bain court cases. Our panel of lawyers and plaintiffs examine how success of these two lawsuits will affect teacher freedom and could change the face of education and the political landscape nationwide.
So I realized from personal experience that there was absolutely no way for a teacher to change things from within. The unions do not speak for the teachers they claim to represent. The unions speak for themselves. We want teachers to be able to decide for ourselves without fear or coercion whether or not to join or fund a union.
They don't want to pay money to an organization that they have to turn around and fight when they're trying to promote issues like school choice and charter schools.
I then realized there's teachers and there's CTA. They're not connected.
Bain and Friedrichs have one very important thing in common, which is to give teachers more choice.
I got into all this business back in 2005. Some of you, or maybe many of you, remember Prop 75, which was a paycheck protection initiative back when Arnold was a governor. And at that time, the default position for teachers paying the political part of their dues was in. Prop 75 would have made it where the default position was out and teachers would have to voluntarily pay union dues. Pay the political part of union dues. The prop is very popular going into the summer with both teachers and other public employees and the general public. However, over the summer, the teachers' union spent millions of dollars, and all public employee unions spent millions and millions of dollars, and quite frankly lied about the effects of the prop. They said, for example, that teachers would lose their pensions if the prop flew. They said that cops people would find out where cops live. All of this is lies. None of this was true, but people bought it, and the prop went down. It left a very bad taste in my mouth. And I co-founded an organization at that point called the California Teachers Empowerment Network. And we vow to get information to teachers that they don't get from their unions and they don't get from their school districts, because frequently that information comes with spin. And then a few years later, we expanded that, our mission, to include the general public, because the general public gets their information from the mainstream media. And I'll be kind here, that's not the best place to get real information. Fast forward to 2010, I was involved with Unplug the Political Machine, which was born right down south in Orange County. That never made it on the ballot. Then there was a proposition in 212 called Prop 32, which did get on the ballot, but it failed. And lo and behold, 10 years after Prop 75, we have two major lawsuits, which could put a dent in public employee unions' hegemony. Most notably the teachers' unions. And that's what today is about, and that's why you're here. Very briefly, the Bain case. The Bain case is about teachers who want to stay in their union, but don't like the union's political agenda. The way things are now, you can get out of paying those political dues, but you have to resign from the union. The Bain people are saying that's not fair. You should be able to stay in the union and choose not to support the union's political agenda. The Friedrichs case is a little bit different. The Friedrichs lawyers are arguing that all union spending is political, and therefore teachers should be able to opt out of all dues payments. Okay, Rebecca Friedrichs has been an elementary school educator for 28 years. Since the first day of her career in 1988, she's been concerned about the policies and politics of the teachers' union she's forced to financially support. She served on her local union board for 3 years with hopes The union representative would listen to common sense and reason, but discovered that while many reps agreed with her concerns, she was unable to make any positive impact because even they were afraid to speak up to union bosses. Today, she's the lead plaintiff in a seminal federal lawsuit attempting to restore the First Amendment rights of free speech and free association to millions of public sector workers in the United States. Rebecca Friedrichs.
So Larry asked me today to share my personal story. Why am I here? What is it that brought me to this place today where I felt that the only way I could achieve my First Amendment rights to freedom as an American citizen was to file a lawsuit? So that's the story I'm going to tell you today. It's a very personal story, and I won't be talking about all of the ins and outs of the case. I'll leave that up to my lawyer too. So my battle against forced unionism began in 1987 when I was a student teacher. I was teaching in a classroom with an outstanding master teacher, learning how to love children, how to discipline children. It's a great experience. But next door to us was a teacher who, in my opinion, was quite abusive with her little 6-year-olds, first graders. She would grab them, yank them, yell right in their faces. This was just to get them in line. This is what I was seeing outside the classroom. I have no idea what went on inside of her classroom, but I was very troubled by what I witnessed outside. So I asked my master teacher, what can we do about this very obvious problem? She sat me down and she said, today, Rebecca, is your lesson about the teachers' unions, about teacher tenure, and how difficult it is for school administrators to rid themselves of teachers who are no longer effective in the classroom or who may even be abusive toward little children. So that day I decided I want nothing to do with an organization that would bring harm to the very children I'm vowed to protect and serve and educate. So that was my first distaste with the unions. Fast forward about 3 years. I think I was a third-year teacher, and at that time there was a voucher initiative going on here in California on the ballot. And every mandatory staff meeting was dominated by talk of how evil vouchers were. That if the vouchers were passed, we would all lose our jobs. If vouchers passed, it would ruin public education, it would ruin the kids. They'd be tested all day long, as if they're not already. And it was just this gloom and doom. The teachers were terrified. So, being a free-minded, independent thinker, I started attending debates to hear both sides of the issue. I came out in favor of vouchers. They seemed like a really good idea, good way to save the taxpayers some money, give parents choice. So I go to my mandatory staff meeting, and we're all basically being browbeaten to march for the unions, for their side of the debate, and to make phone calls and pass out flyers. And so they're passing around the little sign-up sheet, putting pressure on everyone, and I said, no, thank you. I won't be signing up. Tried to leave it at that, and I was confronted with, well, why not? And I said, well, I've been doing research on this, and I'm actually in favor of vouchers. I think they're a good idea. And right there in my mandatory staff meeting, my union rep said, well, you're a radical right-winger. So, name calling. And my first thought was, if it's radical for me to do what's right for my students and their parents and the taxpayers as a public servant, then I'll be radical every day of the week. So, I didn't take it to the put down, but that was surely how it was meant. Now, I think it's about 10 years ago, maybe 9 years ago, I decided, okay, I'm going to serve on the union board within my district. Surely they can all listen to common sense, we'll work together, because I noticed the teachers in my district, a lot of them agreed with me. They were just too afraid to speak up. So maybe we could all work together and make a difference. So I serve on my union board, and to my shock and horror, I couldn't get anyone to listen. I would go to meetings, and every month I'd bring up the same thing teachers in my school are concerned, they're troubled with the way our money's being spent on very far left politics. They'd like to have a voice. We all see things a different way. Can't we work together, give everybody a voice? And I received the same answer month after month, and this was the answer. That was it. It was just shrugged shoulders. And so I kept pushing and pushing, and I went to an annual leadership conference with the CTA and NEA leadership there. Brought up my questions there. That resulted in more of the name calling, the radical right-winger stuff. So I realized from personal experience that there was absolutely no way for a teacher to change things from within the union. And there's several teachers in this room who know exactly what I'm talking about, because they've done it too, and it won't work. So that's how I got here. While I was serving as a union rep, come on in. I just want you to know one of the things that happened. So here I am, union rep, and we find out, this was when the economy was starting to tank, we find out that several of our very gifted teachers were about to be laid off. They weren't tenured, so they were going to lose their jobs. They were outstanding, high test scores, they were doing wonderful things, parents loved them, kids loved them. So I went to the union board and I said, look, as representative of my school, a lot of us have been talking about the possibility of taking a small pay cut, 2 or 3% pay cut, to save their jobs. Could we talk about that? Absolutely not. They would not talk about it. I said, can't we take a survey? Oh, the teachers would never allow that. I said, it's teachers who sent me to ask you the question. Can't we take a survey? Can't we give them a voice? No. So of course, my personality, my poor husband has to live with this, I hounded and hounded and hounded. And finally, they looked at me in disgust and said, Rebecca, look, don't worry about those teachers. We're going to take care of them. The union is offering them a seminar to teach them how to get unemployment insurance. It's so awful, it's laughable. You can't make this up. I said, they're paying you $1,000 a year, and that's all you're going to do for them. The parents in our district are losing their jobs. Many of them have taken huge pay cuts. We can't take a little pay cut to save these jobs and keep the class sizes down and do what's right for the kids. No. So that was one of the last straws that caused me to move on in my battle. So what these stories illustrate to you is that the unions do not speak for the teachers they claim to represent. The unions speak for themselves, period. They do what's right for the union leadership, and they do what advances their political agenda. They're not speaking for the rank and file teachers who are paying the bill. And in my opinion, those who pay the bill should be the boss, and we should be telling them what to do, not the opposite. So, the problem in my mind comes down to core values. The union's core values are in direct opposition to my core values and to the core values of many of teachers who are forced to fund the union politics. Everything the union does, politically and in collective bargaining, all of it is driven by their core values. So unfortunately, everything they do is directed toward their political agenda. So teachers who have an opposite belief system or core values are being forced to fund policies, ideas, collective bargaining issues that are in direct opposition to their own core values within the workplace and within their community. We think this is an egregious attack on our First Amendment rights. So that is why I'm here today. Because of the dichotomy of these core beliefs and my realization that I couldn't do anything from within, I sought to change things from without. So I started writing editorials, having no idea if they'd ever be published. And those editorials led to connections to wonderful people like Larry and to my lawyer and to this, I think, wonderful lawsuit that is giving a voice to the many teachers out there and other public sector employees who have been forced to fund so many issues against our will. A little bit about collective bargaining. All of us are forced to pay for collective bargaining. So if you opt out, the unions will bring that up a lot. Well, she can opt out. Why is she complaining? Well, as Larry mentioned, we can only opt out of the overt politics that the union claims are overt politics. We cannot opt out of the collective bargaining. And in our opinion, the collective bargaining is just as political as the political stances. So in our opinion, all of the money is going to political causes. For example, when the unions fight for laws, like tenure laws, and they use their political piece of their money to fight for these laws, and they pass these laws, like tenure. Well, tenure impacts the grievance process within collective bargaining. So here's how it works. Seen this with my own eyes. My poor husband has dealt with this personally as an administrator. You have a teacher who has tenure. Teachers may be abusive, or the teacher's just not getting the job done. And the administrator would like to rid of this teacher for the good of the children and the taxpayers. Can't do it. Teacher has tenure. So the administrator decides, okay, I'll discipline this teacher. I'll, write things up, and either this teacher can do what it takes to improve, or teacher will have to leave. Well, what happens to this as an administrator is he or she runs right into the collectively bargained grievance process. So this grievance process is so ridiculously convoluted, it's almost impossible to get rid of a low-performing teacher. So the administrator's hands are tied. They cannot do what is right for the students, for the taxpayers, for the other teachers, for anyone involved. So the taxpayer ends up paying for teachers who are proven failures. And in my case, and probably the case of many of you in this room, I not only fund through my tax dollars teachers who have negatively impacted my own children, but I also fund it through my forced union dues. And we think that's a big problem. So, we just want one thing. This is what I'd like to leave you with today. One thing. It's very simple. We want teachers to be able to decide for ourselves without fear or coercion whether or not to join or fund a union. Period. That's all we're asking for. And we're very grateful to the United States Supreme Court Justices for offering us a day in court. I'm very excited about it. Thank you for being here today.
Moving right along, Terry Pell is president of the Center for Individual Rights, a public interest law firm that is helping to represent Rebecca Friedrichs and the other plaintiffs in the Friedrichs versus CTA case. He received his Ph.D. from Notre Dame in 1996, his J.D. from Cornell Law School in 1981, and his B.A. from Haverford College in 1976. Prior to working for CIR, he worked as an attorney with the firm of Aaron Fox. From 1985 to 1988, he was Deputy Assistant Secretary for Civil Rights in the U.S. Department of Education. He later served as General Counsel and Chief of Staff at the Office of National Drug Control Policy. He joined CIR in 1997. Terry Pell.
Thank you, Larry, and thanks to all of you for coming out today to learn about two lawsuits that could fundamentally change and give teachers greater say over the unions that represent them. Let me say a little bit about the Center for Individual Rights because it bears on this case. The Center for Individual Rights was founded about 25 years ago. We are principally a First Amendment public interest law firm. We try to bring a handful of cases that we think raise important issues of individual rights in the area of First Amendment, in the area of free speech, and cases that we think we can get to the Supreme Court and win and set a legal precedent that will essentially change the landscape of the law for, we hope, decades to come. I say all of this because the case that we're involved in today, or that we're talking about today, the Friedrichs case, is a First Amendment case, but it builds on the work of another public interest organization, the National Right to Work Foundation, which has been working in this area for, 25 or 30 years, a lot longer than we've even been in existence. And a lot of the cases that we are relying on to bring the case, the Friedrichs case, are victories that were won by the National Right to Work Foundation. So we're greatly indebted to the work of that organization, and we're collaborating with them quite a bit in the Friedrichs case. Okay, well, let me just give you a quick overview about Friedrichs. As I think most of you know, and as Larry mentioned, at the end of June, the Supreme Court granted review of this case. That does not mean we've won the case. It just means the court is going to hear the case, and there will be, we've just submitted a number of briefs at the beginning of September. It's now the other side, the defendant's turn to submit its briefs, and then there'll be oral arguments sometime in December or January, we're not sure yet. And then we should get a decision sometime next spring. If we win, what we will do is strike down the compulsory union dues laws for public employees unions that now exist in 25 states. So essentially, with one Supreme Court decision, we will make every state in the country an open shop state. So this will be a big change. And in particular, what's significant about it is there'll be a change made on the basis of the Constitution. So what the court will be ruling is that individuals have a right under the Constitution to not be subjected to compulsory dues. That means this change will happen without a lot of the political efforts that were necessary in states like Wisconsin. It will be less of a divisive issue about collective bargaining and more of a principled decision about the rights of individual teachers to make certain decisions for themselves. Okay, Rebecca talked about what the case means to her and why it is important to her and to other teachers. I'm going to talk a bit about the legal strategy that we're using in this case. I want to talk about the claims we're making and, just important, the claims that we're not making, so that when I'm done, you'll have a better sense of what this case is about as a legal matter. Our basic claim is straightforward. The First Amendment prohibits states and the federal government from forcing individuals to speak out about any particular issue, to support the speech of organizations through dues or payments. The principle of compelled speech in the First Amendment also embraces the right to not speak. Individuals have a right to decide for themselves when to join the public debate, how to join the public debate, if to join the public debate, and if they do decide to join the public debate, which side they want to take. The state may not force any of this. And the reason why the First Amendment grants these very broad rights to individuals, speech rights, is that in our country, the sovereignty of our government rests with the people. The government is not the sovereign, the people are. And the people decide freely, without coercion, what authority to give to the government. And so since the government is dependent upon the free choices of individuals to make decisions about what the government's authority really is, it doesn't make sense and is theoretically inconsistent, so to speak, for the government to be controlling and manipulating the very acts of speech by which its own authority is determined. So freedom of speech is hugely important. It's probably one of the most fundamental rights in the Bill of Rights, and it's the basis for a lot of the other rights and a lot of the things that our country takes for granted in terms of the government being responsible and accountable to the people. Okay, well, Friedrichs would change current laws. I think Rebecca mentioned the Supreme Court about 25 years ago acknowledged that teachers and other public employees have a right to opt out of a portion of their union dues, specifically the portion that's used for overt political activity. It's a straightforward application of the First Amendment. It makes total sense. What the court is basically saying is a portion of what the union does is exactly like what a political party does. They spend money to try to get legislative changes. And teachers, nobody, the state actually is not authorized under the First Amendment to compel individuals to support that kind of political activity. It would be just like if one party won a national election and required everybody to pay dues to that party. Well, we all understand that's wrong. And to the extent that unions engage in overt political activity, the state cannot compel support for it. Well, we're asking the court to go one step further and rule that not only may teachers opt out of the political portion of the dues, but in fact, they have a right to not pay even the portion of the dues that's used for collective bargaining. This is what's normally called an agency fee, and even a teacher who opts out of the political portion of the dues has to pay an agency fee each year as a condition of employment. And what this is supposed to be used for is the ordinary administrative expenses of the union in negotiating a contract and then implementing that contract once it's negotiated. And what we're claiming, as Rebecca mentioned, is that even the collective bargaining activities of a public employees union are inherently political. And in our view, the state may not compel financial support for even though that collective bargaining activity. Well, why do we think that collective bargaining is inherently political? I mean, after all, a lot of collective bargaining is about salary and other sort of routine workplace issues. And I think we all understand the First Amendment doesn't protect all speech. Public employees, for example, do not have a right under the First Amendment to publicly criticize the policies of the agency they work for. I mean, there's a famous case where a law enforcement officer, let's just say a deputy sheriff, wanted to go out and publicly criticize his boss, the sheriff, and he claimed a right under the First Amendment to just say what he thought about what the sheriff was doing and what his priorities were. And the Supreme Court said, no, when you join the federal government or when you go to work for any employer, you give up certain First Amendment rights. And even public employees do not have the right to criticize their own boss or essentially divulge confidential information or any of the other things like that. Well, the unions take the position that collective bargaining is essentially an efficient way to mediate kind of minor workplace disputes, that it's not political and everybody should be forced to pay for it. We're arguing, however, that that's not the case. And, obviously what's political is sort of in the eye of the beholder. There are many sort of ways to think about what's political. And what I'd like to do is offer just several suggestions of the things the union bargains for in collective bargaining that we feel are political, and a lot of teachers feel are political and feel very strongly about these things. So let's just start with salary. Everybody thinks, well, okay, salary. What teacher could disagree with the union's efforts to secure greater salary? Well, the fact is that when a public employee union is negotiating with a local school district over salary, they're negotiating over the best use of tax dollars. They're essentially going to local officials and saying, we think more public money ought to be spent on education rather than parks or welfare or libraries or anything else that a local government spends money on. Well, we think that's an inherently political issue. Reasonable people can disagree about how much of the taxpayers' money actually ought to be spent on education. And I think this issue has come to the fore in California, where when you're in a period of economic retrenchment and local governments are going bankrupt, reasonable people can disagree about whether the unions ought to be demanding higher salaries for any particular set of public employees. I'm not saying every teacher agrees that they should not be asking for higher salaries, but some teachers feel very uncomfortable about that. That's a political issue. So even an ordinary issue like salary can become political when the underlying issue is what portion of the tax dollars should go to this activity rather than that activity. But there are other political disputes that the union gets involved in collective bargaining that are in some ways more important than even salary. For example, one of the biggest political disputes today has to do with the unequal educational opportunities available to particularly poor students living in bad areas. And I think everybody understands that we have a problem in this country. There are a lot of very bad schools that serve primarily low-income and very oftentimes minority students. There's a huge fight everywhere in the country about what to do about this. There are a number of organizations and individuals that have offered different solutions like school choice, vouchers, charter schools. These are all efforts to get at this problem. The problem is that a lot of what the union negotiates for make those fights much more difficult, and in fact are in some ways the source of the problem that all those fights are designed to address. What do I mean by this? Well, one of the things that the union presses for during collective bargaining is that all salary ought to be tied to seniority rather than competence or merit or demonstrated proficiency. Another example is that the tenure laws are built on seniority rather than competence. Teacher assignment rules, which are negotiated for during collective bargaining, are designed to allow a teacher with seniority to teach in whatever school he or she wants. These decisions have to be honored by the school district regardless of student need or school need or any of the educational problems that the school officials have to address. So what the result of these kind of policies that the union negotiates for in collective bargaining is that we have some really bad schools in some really bad areas, and there's nothing anybody feels that they can do about this. Every effort to try to fix this problem runs into these seniority rules that the union has negotiated for during collective bargaining. Now, obviously, not everybody agrees with me. Not every teacher agrees that there's a problem with seniority-based rules, but some teachers do. And for those teachers, it's practically a moral issue that they have to pay money to this organization, which is creating this problem of really terrible schools that makes it very difficult for students living in a low-income area to get even a minimally useful education. They don't want to pay money to an organization that they have to turn around and fight when they're trying to promote issues like school choice and charter schools and all the rest of it. So it's not a question of whether an individual happens to agree with this policy proposal or that policy proposal. The First Amendment point is that the union takes a position during collective bargaining that is on one side of a very contentious political dispute that's been going on for 20 years and is getting more contentious, by the year. That's what we mean by the union taking political positions that should not be the basis of, it should not be supported with compulsory dues. Teachers should be free to decide for themselves whether they agree with the rules of seniority that the union's negotiating for. If they do agree with those rules, fine. Join the union, pay the dues. The union is a very effective advocate for that point of view. If you happen to be among the minority of teachers that disagrees with that, you shouldn't be forced to support it. It's a simple principle, under the First Amendment. So that's what this case is all about. We think the case raises a fundamental issue of individual rights, and we're very pleased that the Supreme Court has agreed to hear this case. It's one of those cases where, from the time we brought this case to the point where the Supreme Court will hear it and decide it, it's been a relatively short time, almost 3 years, or no more than 3 years. And this is a good thing. We'll get a quick answer next May, and then we'll know what to do next. Thank you.
Terry used that magic word, seniority. I think our next speaker has had a bit of experience with that. Our next speaker is Ms. Bhavini Bhakta, a teacher for 12 years. She's won awards for her work and has been a leading voice in the effort to change the education system to better serve students. In 2014, she delivered powerful testimony in the landmark Vergara case, and in 2013, she spoke in front of the California Senate Education Committee, urging them to pass legislation enacting a new teacher evaluation system. She has become increasingly troubled by the problems facing California schools and her union's opposition to change. She has learned that state-level teachers' unions are the biggest financial supporters of the very legislators who block the reforms for which she has fought. With this case, she hopes that the court will protect her First Amendment rights and ensure that neither she nor any teacher be forced to support educational policy that negatively impacts student learning. Bhavini Bhakta.
Thank you, Larry. So I think, as Larry mentioned, I just started my 12th year of teaching this past August. And the first 8 of those 12 years were a tumultuous time in our economy, where districts across California were attempting to figure out how to operate their schools with far less of a budget than they were accustomed to operating their schools with, which naturally meant cuts in personnel and cuts in programs. With that said, in my first 8 years, I received 6 pink slips, 6 layoff notices. And that's a whole nother story that I fought with Vergara, so I won't get into that piece. But each time I received a pink slip, I approached a union representative at my school site. And in those years, because I was being displaced from site to site, I had worked at over 5 sites in those years. And so each time it was a different union representative I spoke with, and the conversation just centered around, okay, so do we have to lay off teachers by seniority? Is there another way we can do this? Can we talk about this? Can we perhaps use teacher evaluations and use that as a factor in determining who is to be laid off? Can we come up with another idea? Can we just talk about this? And every union representative, the answer was pretty much the same, that, well, this is really a state level policy and a state level issue, and we can't really do anything about it, so you just have to live with it and you'll stop getting pink slips one day. And I said, well, I don't want to live with this, and I'm not going to just live with this. So I got active at the state level. I said, okay, I'm flying up to Sacramento, and I'm going to talk to senators and assembly members who will listen. So I spoke at many Senate Education Committee hearings about teacher evaluations and seniority-based layoffs and various issues. And one particular hearing stands out in my head to date, even though it was a couple years ago. I remember it like it was yesterday. I flew up to I took a day off of work, which I hated doing, still hate doing, because lesson plans are just tedious. But I took a day off of work and I flew up to Sacramento, and I spoke on behalf of Senate Bill 441, which we really put that bill forward to say, let's make teacher evaluations 4-tiered instead of 2-tiered, because currently teachers are evaluated and the evaluation says you're satisfactory or you're unsatisfactory. And there's no room for you're exceptional or you really have to find another job. There's nothing, it just says satisfactory. So the teacher of the year is in the same category as the teacher who needs a mentor to improve. So we said let's make 4 tiers and let's have districts decide what the 4 tiers are, and we could say ineffective, approaching effectiveness, effective, highly effective, and we said why not? We grade our students on more than 2 tiers, so let's grade our teachers on more than 2 tiers. We spoke on behalf of this, and not only did I speak on behalf of urging the senators to vote yes on this bill and give us 4 tiers. 170 other teachers were there that day. Parents, Julie was there, parents, community members who said, we need 4 tiers. This makes sense for us. This will improve instruction. This will improve our schools. This will improve lives for students. We get through the end of the hearing, and I noticed that beyond the 170 that were there in favor of this and giving compelling arguments, there were 2 who were present in opposition. And I learned that the 2 were a lobbyist for California Teachers Association and another for the American Federation of Teachers. And the hearing ensues, and they, the CTA lobbyist goes on right after I speak and give my argument for why we need a 4-tiered evaluation system. And she says, this bill and this evaluation system will harm teachers, and teachers don't want this, so vote no. And I was sitting right next to her, and I said, wait a minute, I am a teacher, and I am here, and I want this, and so do the 170 people who are here want this. And you are speaking on behalf of me as a CTA representative saying that I don't want this. And I quietly thought to myself, let me check my email really quick. Let me see if I got a survey from CTA that said, do you want a 4-tiered system or not? Did I miss it? Where did she get that information from that she is now sitting in front of these senators saying? And I also remember $1,000 coming out of my paycheck to this organization that represents me, that uses teacher in their title, and I am the teacher. And so that continued. The representative from American Federation of Teachers said virtually the same thing, that this will harm teachers and it doesn't benefit really anybody, so let's keep the 2-tiered system. And the senators, long story short, the senators at the end of the day, the majority of them refused to cast a vote, claiming it was too difficult of a decision to make. And one senator walked out during the voting process, so he wasn't even present. And one senator, I live in her district, and I voted for her when she became elected. And so I genuinely was stunned. Silence in that hearing room. And we stood outside in the hallway, not knowing what to say. When I'm teaching my students, I had my substitute teachers stream this hearing in my classroom so my kids can understand that when you speak up, then the majority rules in this country. And I was stunned to the point of tears that, what am I going to say to my students tomorrow? They're watching this. They watch this. And I cannot tell them what actually happened here. And as we're talking about this, so one of the senators who did vote yes came out to the hallway and stopped a group of us and said, hey, you guys, please don't get discouraged. Please keep fighting. Please keep coming up to these hearings. You cannot stop because they need to hear you. And I looked at him and I said, why? There's 170 of us. And they didn't listen. And he said, well, these senators in this committee, they're my friends. We are friends. We spend 5 days a week here together. And he said verbatim, with 6 of us present, that CTA controls their vote. And I said, wait a minute. I am CTA. I pay dues to CTA. So I am the teacher in California Teachers Association. So which CTA are you talking about that controls their vote? Because there's 170 of us who are the teachers in California Teachers Association, and we should control their vote. And he, stunned himself, said, look, these guys run for re-election, and CTA funds their re-election campaigns, and hence they have to vote how CTA wants them to vote. I wish I recorded it. So I come back to LA and I said, there's 2 CTAs, clearly. I don't know which CTA that one is, but this is the one I know, the one I'm a member of. And the constituents are 300,000 teachers in California. And I asked teachers at my site, the 5 sites I had worked at, I asked union representatives, I asked our executive council of our union board, I asked our union president. I said, have you guys heard of this bill? Did you guys get asked whether you want a 4-tiered evaluation system or 2-tiered? Have you guys heard of this? Did CTA tell you guys this? Did we get something that Absolutely not. Not one person, not my union president, nobody had heard of this bill. Yet there was somebody claiming to be us in the Capitol building saying we didn't want this. And so I then realized there's teachers and there's CTA. They're not connected, we're not communicating. If our union president, when we are a chapter of CTA, doesn't know about a bill, yet CTA is in Sacramento voicing themselves on behalf of us, and it's a gross misrepresentation of us and it may not be a misrepresentation, but I would like the proof of that, a survey or something that says most teachers want a 2-tiered evaluation system. I can live with that if that's what the majority wants. But it struck me that there's just 2 entities. There's teachers and then there's CTA. And so at that moment I went to my union rep and I said, how do I not pay them? What do I do? I don't want to have my $1,000 a year go to that woman who is speaking on behalf of me and that entity that she represents, because I represent a different entity, and that's teachers. And he said, you can't. And I said, what do you mean I can't? And he said, well, you can't not pay your CTA dues unless you become a non-member of our union, local union. And I said, well, I don't want to be a non-member. I want to run for union rep next year, and I want to vote on my calendar, and I want to vote on my benefits, and I want to be a part of what pertains to me here in my district, in my daily life. And he said, you have no options. He's like, if you don't pay that political portion, the CTA portion of your dues, you cannot be a local member. And I said, wait a minute. They silenced me in Sacramento by saying teachers don't want this. CTA stripped me of my voice over there when the senators didn't vote. And now I'm here saying I don't want to take part in that. And I said, let me get my money and give it to you. Let me give it to my local union. And even here, they're stripping me of my voice on the local level in my daily life. So at that moment, I said, I'm trapped in some sort of CTA matrix here that is not, I can't, I experienced the state level portion of it, and I said I don't want to be a part of that, and I'm here in my daily life, 12 years in, and either you pay into that or you don't be a union member. That conflicts with my fundamental beliefs. And at that moment, I said, okay, what am I going to do? I'm moving so far away from conversations that I want to be in, which are about seniority-based layoffs and teacher tenure and how to improve instruction and change policy to make schools a better place. And here I am fighting something that, as a citizen of the United States, I should not be fighting for. This is a guaranteed right for me by being born here, of being a citizen. And I was talking to Josh about it earlier, and I said, I can't believe we're spending time on this in this country, that I don't have a choice to decide where $1,000 out of my paycheck goes. And so I became involved in this case with a wholehearted belief that the judge will uphold our Constitution and recognize that we as teachers believe certain things, and whatever we believe, that our state level and our national entities are a gross misrepresentation of who we are on the ground. And I genuinely hope that our case and our judge rules in our favor, along with the Friedrichs case. Both are very compelling cases, and I just hope that both of these cases recognize that we're in the United States of America and we have this choice. Thank you.
And last, and certainly not least, Josh Lipshutz is a partner in the San Francisco office of Gibson, Dunn, and Crutcher. He currently practices the firm's litigation department and its appellate and constitutional law practice group. His practice focuses primarily on constitutional, class action, and securities-related trial and appellate matters. He has represented clients before the Supreme Court of the United States, the Ninth Circuit Court of Appeals, the California Supreme Court, and other state and federal appellate courts. He served as a judicial clerk to Antonin Scalia, the Supreme Court Justice of the United States, and Alice Kaczynski of the United States Court of Appeals for the Ninth Circuit. He graduated Order of the Coif. I assume that's how they pronounce it. It's C-O-I-F, not Q-U-A-F-F. He graduated Order of the Coif from Stanford Law School, where he was senior articles editor of the Stanford Law Review. Josh Lipshutz.
It's actually quick. Thank you all for having me, and thanks, Larry, for putting together this event. As you've heard a lot about the cases by now, so I'm kind of in the cleanup spot, so to speak. But hopefully one thing that you've realized by now is that these two cases, Bain and Friedrichs, have one very important thing in common, which is to give teachers more choice. More choice in the way they spend their money, more choice in the way that they interact with their unions, more choice in the type of political activities that they engage in. There are, however, some fundamental differences between the cases, and I want to make sure that everyone here understands why there are two cases and what our case, the Bain case, does that's different from the Friedrichs case. So as Ms. Friedrichs eloquently explained when she was up, and Ms. Terry explained as well, the teachers that are the plaintiffs in the Friedrichs case are looking to really disassociate themselves from the union entirely. They're looking to be non-members of the union, and they're looking to avoid paying any dues to the union. They don't want their money going to the union in any sense. They are making a First Amendment argument, a strong First Amendment argument in my view, that they have a constitutional right to do that. We are making a slightly different argument. The plaintiffs that are in our case, including Ms. Bhakta, are making an argument that they want to be members of the union. They actually, for a number of reasons, want to be members of the union. And I'll give you a couple of things that have led them to that conclusion. One is they recognize that the unions do valuable things for teachers, in the collective bargaining process in particular. They're out there fighting for teachers, fighting for teacher pay, fighting for teacher benefits, and they recognize that the teachers' unions are, in many instances, out there fighting for them, and so they want to be part of that and contribute to that process. They also want to, as Bhavini explained, want to fight from within. They want to seek change from within the unions. They want to run for their local union offices. They want to have their voices heard. They want to vote on the collective bargaining agreements that their unions are negotiating. And they want to, hopefully over time, and whether this remains possible will be seen over time, but they're hoping that over time their voices will be heard, and that they will be able to either convince the union leadership to change their positions on some issues, or to become part of the union leadership themselves through the votes of other members, and therefore affect change in those policies from within. The third reason that the plaintiffs in our case want to be members of the union. And this goes much more, in some respects, to the heart of the First Amendment claim that we have brought, is that the unions and the state of California together have created a system, as you've heard a few others describe already, created a system where if you are a teacher who does not want your money to go to the union's political agenda, you are actually forced to become a non-member of the union. And when I first heard this, I have to confess, I was floored by this. I did not know that this was the case until we started talking about this case. I assumed, as I think most people assume, that if you're a teacher, you have to pay the collective bargaining portion of your dues. Everyone sort of knows that, and people don't like it, but it's the current state of the law. You have to pay the collective bargaining portion of the dues, and then you have an option. Pay the political portion, or don't pay the political portion. And if you don't want to pay the political portion, you get that money back. It's actually a lot of money. It's about $500 to $600 out of your $1,000. $400 to $600, depending on which local union you're in. And so my understanding as a non-educator, my understanding was that if you wanted to exercise your First Amendment right, it was 40 years ago in the Abood case that the United States Supreme Court held that teachers have a First Amendment right not to contribute to their union's political agenda. That's law. That's not controversial. Everyone, even the unions, will tell you that that's the law of the land. That's been the law of the land for 40 years. And so my understanding of the law was that if you were a teacher and you didn't want to pay the political portion of your dues, you had a First Amendment right to say, give it back. And you would then pay the rest, the part that went to collective bargaining. Well, it turns out that the state of California and the California Teachers Association have devised a fairly clever way around the First Amendment rule that the Supreme Court enacted 40 years ago. What they do is literally bundle your right to opt out of the political process, to opt out of the political portion of dues, together with a whole bunch of really good stuff, really important benefits that they know teachers want very badly. What are these benefits that they've included? Disability insurance, paid maternity leave. So if you are a teacher and you are a non-member of the union, in other words, you're a teacher who has exercised your right to not contribute to the union's political agenda, you do not get the benefit of the union's paid maternity leave plan. And what have the unions done across the state of California? They have opted teachers out of the state disability insurance plan. So teachers, most employees in California, when you take maternity or paternity leave, you get paid your full salary by the state of California, not teachers. The unions have opted teachers out of that state program and have decided instead to provide paid maternity leave themselves only to their union members, so that it's bundled together with a teacher's willingness to contribute to their political agenda. Life insurance, death and dismemberment insurance. Your ability to be represented in a grievance process or a adverse employment action. If you are a teacher and you are disciplined, laid off, have adverse employment action taken against you, if you are a union member, the unions will provide an attorney to represent you. If you are not a union member, you're on your own. Now, these are the very types of benefits that the union is entrusted by the state of California to be negotiating on your behalf as a teacher with the districts. And lots of other unions have managed to get these very benefits from their employers. As I mentioned, most employees in California benefit from the state's disability and maternity leave programs. Most employees in California have a process where they get an attorney if there's adverse employment action taken against them, but not teachers. And the reason is not because the teachers' unions aren't powerful enough to negotiate these benefits from the state. It's because the teachers have found a way to bundle those benefits with the political dues so that if you want to opt out of one, you have to opt out of the other. And we view that as outright coercion. And the First Amendment does not permit coercion. For the same reasons that the First Amendment prohibits the state and the school districts from forcing teachers by simply taking the money to contribute to the union's political agenda, it just as well prohibits teachers from being coerced into contributing to the union's political agenda. And that's the point of our suit. And so, whereas the Friedrichs plaintiffs, if they prevail, will give teachers, hopefully in California and elsewhere, the option to completely disassociate themselves from the union and become non-members who pay nothing. Our lawsuit, if successful, will give teachers yet another option. And the option is, stay a member of the union. The union does good things for you. Stay a member, contribute, pay for the collective bargaining portion of your dues, run for office, fight for change within, and don't give up your benefits. or your voting rights. There's no reason why you should have to give up important benefits like life insurance, maternity leave, disability insurance, just to speak your mind from a political perspective. You should not, those two things do not go together. And that's the point of our lawsuit. And that's really what I'm here to say. I'm looking forward to all your questions, and I can get more into the details if you like at that time.
Thank you all for an excellent and concise description of the two cases. Before we get into your questions, I just have a couple of comments and I want to ask a couple of questions. Mostly talking about how this is going to affect teachers, but these cases will have much wider implications if they fly. This is a pretty hip room, so I don't have to tell you how powerful the California Teachers Association is. Just some numbers here. From 2003 to 2012, CTA spent $102 million on political contributions, 0.08. It's less than 0.1% went to Republicans. Okay, now this isn't a Republican-Democrat thing in the sense that because I'm a Republican, I'm saying, you know, my ox is gored. I'm saying this isn't fair. Now, the teachers' unions gave over 99% of their money to Republicans. I would be just as angry. I shared a panel with Dean Vogel, former CTA president, who one-on-one's a lovely person, by the way, a couple of years ago, and he said that in California, teachers break down 65-35, 65% of Democrat, 35% Republican. That sounds about right in our state. So you would think that maybe 65% of the money would go to Democrats and 35% would go to Republicans, but as I said, over 99% goes to Democrats. It's just wrong. It's just wrong.
Well, if I could jump in, or you would expect about 35% of teachers to be opting out of the political portion of their union's dues, and it's not that way because of the coercion that I just described. Only about 8% of teachers, 8 or 9% of teachers actually do opt out. And so that speaks to some of the coercion that I was discussing.
Yeah, very few. I've heard about 10, 11, but yeah, we're in the same ballpark for sure. The CTA, I'm acquainted with Gloria Romero, former state senator and a Democrat. And she told me that CTA considers itself the fourth branch of government, that they consider the assembly their house. And they do. She's right. And this is coming from a Democrat, so once again, it's not really a partisan issue that I'm making here. I do have a question about the Bain case, but I want just to, we touched on, both Josh and Bhavini touched on seniority. Just to show you how ridiculous this system is. Bhavini, you shared a story with me about how you and another teacher were both hired on the same day, and therefore, who was going to get laid off? Can you just tell everybody very briefly how the decision was made?
Absolutely.
Yeah, you each have mics to share.
So this was in one of my 6 years of getting pink slips, and actually a friend of mine, I was in her wedding, we both got hired on the same day, and they couldn't distinguish who was going to get laid off. Both of us had received Teacher of the Year awards prior to this day, and they kind of pinned us against each other. We had the same degrees, same master's program, all of that, and they said there's no tiebreaker criteria beyond what they had already assigned us points with. So basically, now that we're at the same place, you guys will have to come into the district office and pick tiles, numbered tiles, of who's going to keep their job and who's not. And so I made the decision to not go. And I told her, you can go, you can pick my tile, whatever happens, happens. At this point, this is a random chance game, and so dehumanizing and belittling that I choose not to be present. And she didn't want to go either, and I said, well, one of us has to, and she went. And she picked her tile, she picked my tile first, and she picked hers, in a room full of other people who were also tied at different levels, so they had to do this after us. And she picked the higher number, the lower number, whichever one. She picked the one where she retained her job, and I was laid off. So I went to go look for a job in another district.
That's what seniority is for. Okay, I do have a question for, I guess, Josh or Bhavini, which either of you want to answer this. I talked in my opening about Prop 75 and, opt-in, opt-out. Does the Bain case address that, or is it just after the fact, teachers don't have to resign from the union.
And the Bain case does not address the opt-in or opt-out issue. I believe the Friedrichs case does, but the Bain case does not.
As a second claim, if the court does not agree with us that teachers have a First Amendment right to not pay any portion of union dues, our second claim is that if that's the case, then teachers, the current opt-out system, which requires teachers to opt out of the political portion of the dues, should be replaced with an opt-in system. The argument being that teachers shouldn't have to chase around and jump through numerous hoops in order to avoid funding political speech with which they disagree. Rather, the union ought to be on the hook to recruit the teachers that want to make these political expenditures. So it just would flip the burden from the system that we have now to the reverse.
I just want to add one thing. We were talking about seniority. We didn't really touch on tenure, or as the teachers' unions prefer to call it permanence, or as they're now calling it due process. And I'm a former teacher, and this is not teacher bashing, believe me, but in California, about 300,000 teachers, about 10 a year who have permanence lose their jobs. 10 out of 300,000. Now, I'm sorry, there are more than 10 bad teachers in California. I don't know how many there are, but there are more than 10. By the way, I have to say that out of those 10, 8 of them are criminals.
Yes, that's what I was saying.
8 of them are people like Mark Byrne, who's in jail for doing unspeakable things to children. 2 out of those 10, or 2 out of 300,000, if you want to look at it that way, lose their jobs because they're incompetent.
That's right.
There's something wrong with the system, clearly.
Larry, let's be fair, it's 2.2.
2.2. That 0.2 person must be very interesting about that. Okay, then we're going to go into the audience, and before, we're not using index cards, so I would just ask you to please ask a question. No speeches, please. Ask a question, and if you have any affiliation that you want people to know about, or that has bearing on your question, please do that first. Okay, questions?
Yeah, I'd like to ask the two attorneys, if you could. I'm Robert Blankholm from Irvine, California. I'm a friend of Rebecca's, have no affiliation with the teachers union or yours, Larry. In the Uniform Commercial Code, there are laws against self-dealing. There are disclosure laws, there are permission laws, and people go to jail for this all the time. And Dodd-Frank has even made it worse, as I'm sure you're aware. But is there any set of equivalent laws in the government or teacher or administrative sector that allows self-dealing right and left on negotiation of contracts and collective bargaining and all that? Is it a totally different set of rules that is wide open, or is there any culpability there if they engage in it?
So the question is about self-dealing?
Self-dealing. Yeah, self-dealing for their own interest.
For their own
interest. Against the children, etc.
When the unions negotiate with the politicians for raises,
Yes.
there's a quid pro quo that they will actually vote those people back into office. If you do that in the investment business, you'll end up in SEC jail.
I mean, the short answer is there are no comparable rules.
No comparable rules.
And
So they can do it all
the system
day.
is set up to allow exactly that to happen. So it would be not likely that there would be rules against that. That's what the union is, and that's what the collective bargaining system is designed to do.
Well, and there are rules against quid pro quo. Certainly, if you were being overt about it, if the unions would say, you must give teachers higher pay in exchange for our support, literally a quid pro quo. That, I mean, there are laws against it. You can't bribe an official. However, that sounds like a joke. That being said, I mean, take whatever view you want of lobbying in general. I mean, lobbying in general is amassing an amount of money and throwing your weight behind that money and urging politicians to support points of view in order to ostensibly receive your money. However, I will say that we are fortunate in California to have a fairly robust, and this is something that bore itself out in the Vergara case, that's something you may know about, a fairly robust constitutional protection for students' fundamental right to education. And so in California, if the state and the unions are taking actions that infringe on students' fundamental right to education, in theory at least, the courts should step in, the state courts in California should step in and stop that from happening. And that was the premise of the Vergara litigation, was that some of these teacher tenure laws are infringing on students' right to education because they're keeping these ineffective teachers in classrooms in front of students. And so that's been the route that some have taken in terms of litigation, but not, unfortunately, the more direct route they used to go.
Yeah, I would just like, I'm guessing just about everybody is familiar with the Vergara case, but if you're not, it was a case that was brought by a group called Students Matter, and the upshot is that the judge said that the 10-year seniority and dismissal statutes, 5 of them in California, are really unconstitutional, and he used the words shots the conscience. And Judge, you were a lawyer on that case, correct?
Yes, I'm one of the principal lawyers representing the plaintiffs in that case.
Okay, and that's where now it's being appealed by the state and CTA?
The state and CTA have both appealed that decision, and we are before the California Court of Appeal. We're awaiting a similar position. We're awaiting an argument date before the California Court of Appeal.
Okay, and I just read the other day about in Bain, there was some file motion by the union a few days ago?
That's right. So Bain, unlike the Friedrichs case, which is coming to a head at the U.S. Supreme Court, thankfully, the Bain case is really just getting underway. So we're at the early stages of the Bain case. We are before the trial court, which is the federal district court here, in Los Angeles, down here in Southern California. And the unions in our case filed what's called a motion to dismiss. So they are arguing that our entire case should be thrown out and should never get its day in court. And remarkably, the argument that they've made, and we had a hearing on that last week before the judge, and we're going to wait to see what the judge says about it. Remarkably, the argument that the unions have made in our case, in order to dismiss the case, is that they essentially agree that they're doing what we're saying they're doing. They agree that all these benefits are bundled with your right to opt out, and they agree that it can be quite coercive for teachers and really pressure teachers into joining the unions. They say they're allowed to do it anyway. And their argument is that the teachers' unions, are such a private organization. Think of it like a country club. If you want to be a member of a country club, sorry, you have to abide by country club rules. And if the country club doesn't want you, you're out of luck. And respectfully, we have made the argument that the unions are not exactly a purely private organization. They are bestowed by the state of California with the exclusive bargaining rights on behalf of public sector teachers, and so do not have the right to simply coerce their members to join or not join based on their own whims. And so that's the argument that's before the court. And frankly, if we even if the judge, for whatever reason, agrees with the unions on that, that will just get us up to the appellate court sooner and put us in a similar position to the Friedrichs case, where we have appellate judges deciding the very important legal issues.
Do you think that's in your best interest to drive it up or not?
Well, we certainly want the case to go up, but we're happy either way. If the judge keeps the case, we will put on evidence and we will show that this is happening, and we will get the laws struck down and then go up. And if the court decides, you know what, we should go up right now, that's fine with us too.
I have a question about the Bain case, and that goes to what you were just saying, Mr. Sands, and that is that if a teacher opts out of political activity contributions, the union will know about that, of course, and how do we ensure that a teacher then does not have retaliatory action toward them for that? I mean, it stands to reason. Look at the effort they're going to ensure that they get these political donations, and now we're going to say, okay, I'll be in it and you're not, and clearly because it's public, they can look at it and see that I have opted out. Is there a safeguard built into that, or how would you propose that might occur?
Okay, well, so the question is, what about teachers who drop out, or would that also apply to somebody like Rebecca, who would not belong to the union at all?
Either one, but...
Yeah, okay. So the question is about retaliation. Is there anything that...
Well, in our view, part of the reason why we think so many teachers choose to stay in the union, even though they disagree with union politics, is because of fear of retaliation. So it's both the coercive nature of the benefits and voting rights that I described, but it's also retaliation. So part of what Bain is hoping to accomplish is to give teachers a middle road where they say, look, I want to stay in the union, but I don't want to pay for everything you're doing. I don't want to pay for the political portion. And we are hopeful, at least, that will lessen some of the fear of retaliation that teachers currently feel, because Now you have to leave everything behind. You have to become a non-member, and I think the reason the numbers are so low is partly because of that retaliation. If it turns out that even in our world, even in where teachers like Ms. Bhakta can stay in the union but not pay for everything and opt out of the political portion, if it turns out that there's still a great deal of pressure and retaliation even within that system, then we will return to the courts and argue that that is just as coercive as the system we struck down. So I think we're hopeful that by correcting the overt coercion, we will correct some of the underlying stigma and retaliation as well. But if it turns out not to be the case, you'll find us back in court making similar arguments.
That's a good question. I just want to point out that the pressure from the union and the activists in the union can be very, very pointed. I was very fortunate. The school that I taught in to the end of my career, and everybody pretty much knew what I was up to at the end, but I had 1 or 2 teachers who stopped talking to me, but basically my professional and personal life was fine. But other teachers aren't as lucky. And your life can be pretty miserable if you decide to become an agency fee payer, or as the Friedrichs case is trying to accomplish, where they don't pay no money to the union at all. So that's something that I think needs to be we need to be vigilant about.
I have a question for Terry. I assume the Friedrichs case is not a case of first impression, which means the Supreme Court would have to distinguish or overturn a prior decision of the court. Is that correct?
That's exactly right. The decision that we would be overturning is the Abood decision, which created this right to opt out of the political portion of the dues only. And that was one of the arguments that we used to get this to the Supreme Court so quickly, because we basically told the lower courts there's nothing you can do except rule against us under existing Supreme Court precedent. So just do it, and do it quickly, so that we can get to the Supreme Court. And both courts essentially agreed with that, which is why this took a matter of 1.5 years rather than much longer.
So you went to the
District
court. Did you go to it first, the district court, or
District Court? That's right.
And you just said, hey, we got a Supreme Court case, so you can't overturn it because the Supreme Court, the ultimate ruler of the land, says this. So quit wasting your time. Just go directly up there.
Exactly.
Okay, Julie, you have a question?
Well, before my question, I just want to say, yes, I was with Bhavini for 441. That was very disappointing. And in fact, one of the union lobbyists is currently sitting on the California State Board of Education, making statewide decisions for everyone. But my question actually is for you, Mr. Pell. I understand, and maybe you know more about this, that there was recent legislation brought up to kind of go around Friedrichs in case the CTA, I guess, is very worried about this case, but in case of an eventual win. Can you tell us more about that?
Well, what I know about is what I read in the newspapers, and what I understand is that in the last week of the legislative term, the CTA tried to get legislation to would guarantee the union a half-hour time slot to present to all teachers as to why they should stay in the union.
On company time.
Yeah.
On the taxpayer dime, where teachers would have to be forced to hear a union pitch. Now, that got shut down.
It did, okay.
Yeah, but the current legislative session is over.
Right.
But the new one starts real soon, and I bet you anything it will be back. Watch for that one. It's been, Sacramento Bee had an article on it, an editorial, and Steve Greenhut in San Diego Union Tribune wrote about it. It's just priceless. But the good news, it's not happening now. The bad news, it will come back, and I would not be surprised at all if it became the law of the land eventually.
I mean, I think the underlying good news is the unions realize that eventually they're going to have to compete for members and for their allegiance. And that I think is a good thing. And their first attempt is a little bit union-like in that they're trying to coerce this special, half-hour session. But underlying that is the realization that they can't get millions of dollars in free dues each year from the state. They're going to have to go sell themselves. So that's a good thing.
Right, Terry's right. In fact, CTA, I guess about a year ago, came out with a document which Mike Antonucci unearthed called Not If, But When. Because they see the handwriting on the wall. And God knows, I hope your case wins. But if it doesn't, the next one will. And the unions know it. And that's why all of a sudden they're competing for business, just like
the rest of the world. And that's part of why we have the Bain case, is so that when they do have to compete for business, we hopefully eliminate the coercive aspect of it and force them to compete like anyone else.
Other questions? Yes.
I have a question to you, Larry. Considering what you said about 50 years now, the unions really, they were formed at a different time, and now they've kind of taken on a different meaning. I mean, what is their main purpose and value? What value do they bring to the
teachers' unions or public employee unions in general?
Teachers' unions.
What is the value to whom?
Public union.
Yeah, what value is brought into whom?
Well, the value is essentially to their leaders, who frankly make a lot of money and wield a lot of power.
And it's the leaders in their inner circle. It's not doing a whole lot for a lot of teachers. Obviously, we have two here, and not that these are representative of everybody, but they represent a lot of people.
I mean,
Okay, go ahead.
I think part of the issue is that California happens to be a very generous employer to its public employees. The state legislature provides a lot for public employees, and a lot of the things that the unions have to negotiate for in other states, like tenure, for example, they don't have to negotiate for in California because the legislature's already created an incredibly generous tenure system that, you know, is in place as a matter of law. So in California, it is a little interesting that teachers still believe that the CTA is doing them a lot of good. It really, there's a lot of things that are just off the table in California that the CTA has nothing to say about, but still teachers support the CTA. So it's a very interesting question. I don't really know why the CTA enjoys as much support as it does.
It doesn't, well, I know
Another way of putting this is, if you would ever expect to see a free riding problem, you would see it, you'd think you'd see it in California. Because the only thing the unions negotiate for is salaries, and the rest of it's all given to them, you know, by the state legislature, and the state legislature's pretty good on public employee salaries as well. So this is a state where you could get away with not paying a dime of union dues, and you'd still do really well, and yet the teachers don't do that. So even where you'd expect a free riding problem, there isn't one.
So, Larry, can I chime in real quick
sure,
about
yeah,
how that looks on the ground in terms of the value of the teachers union? So when I was sharing my story, I made a clear distinction between CTA and the local union, because I've worked in several school districts over the course of 12 years, and in some districts, the local union was highly malfunctioning because CTA has fully penetrated into that union and kind of controls what the president and the board is saying to teachers. And they're, you know, I think I was talking with one of the plaintiffs in the Friedrichs case, that they'll try to scare you that there's a boogeyman out there that's going to get you if you don't pay your dues or if you're not a member. And then the district I work in now, Arcadia Unified, is a very highly functioning, has a highly functioning union where the president and the board members all believe that teachers should have the right to opt in, and they're 100% behind this case and the Friedrichs case. And to me, that brings a lot of value, because it is the leadership that I want to see, and that is the image that I want a union to have versus CTA. And our local union has actually barred CTA members or any affiliate of CTA to walk onto our campuses because they have. And I'm proud of that, because I'm not on the board, but this is something they fought for over the course of time, because they've so many times misrepresented the facts to our membership. And when our membership asks questions, they try to tell us, well, then they're just going to grade you on tests, but they'll divert from the conversation. And so there's this disconnect, I would say, and then the value that is brought for teachers in our district, or for me, is what your local union does for you, because that is much more relevant to us in our day-to-day existence. And, you know, now where I work, we're having very relevant conversations about, it's never anti-anybody, it's how do we elevate us as professionals, and let's talk about that, versus what I've done in previous districts where CTA has heavily penetrated with political causes, and then we're never talking about anything that pertains to us. So that does vary by district, as Larry mentioned, because some teachers experience the retaliation, and I'm fortunate to say where I work, it's absolutely not that. And I would hope for that to spread to other local chapters without that CTA penetration.
Yeah, let me just make one thing clear. I know most of you probably know this, but for those of you who don't, when you join the teachers union in California, you're not joining a union, you're joining 3. You're either joining your local California Teachers Association, National Education Association, or your local California Federation of Teachers and American Federation of Teachers. And this is a big problem because we know a lot of teachers really like their local union. But unfortunately, it comes with this huge baggage. And that's where most of the teacher union dues go, to the state and national affiliates.
That's right. Yeah, but the political baggage that's an issue in our case is almost all from the state and locals, state and national. It's not the locals.
I would just like to answer it's a good question, say one other thing about it. If there's a teacher union person here, he'd be telling you that it's because collective bargaining gets you a lot more money. Yet, Fordham Institute's Mike Petrelli found, and I'm quoting, teachers in non-collective bargaining districts actually earn more than a union-protected peers, $64,500 on average versus $57,500. I think he looked at 100 school districts. Now, obviously, this varies from district to district. But this is the myth about collective bargaining, that teachers actually make more money because of collective bargaining. And God knows if you're a really good teacher, you're really getting screwed because of wage compression. Because the guy or the woman next to you, who may be half the teacher you are, and been teaching just as long, is making the same amount of money. Questions? Sir?
Like most or maybe all of you in this room, I'm not a teacher, I'm just a dad. But I'm deeply concerned about the fall of education in this state, and mostly blaming CTA. So, my question, I've got a couple, actually I got a ton of them, but I'll keep hurrying. First one would be for Mr. Pell. I'm a little confused about the coverage of the ruling by the Supreme Court. If it does pass, if they side with you. You mentioned 25 states at one point, and then you said something a little bit later in the same paragraph about it being more nationwide. So
It will be a nationwide ruling
okay.
that will strike down the laws in 25 states. In other words, there are 25 states that have laws that would violate this ruling. All states will be bound by the ruling, but 25 of them already comply with it. So the 25 that don't will have to change their laws.
Got it. Thank you. And the other question I have, and this is going to require some educated guesswork, is if you do succeed, and I think we all pray you do, what are going to be the ramifications for the CTA?
Well, that's a good question. As Larry says, the CTA is saying that they're going to go out of existence.
I mean, no, realistically.
Look, I think we have to, nobody, look, first of all, nobody knows. Because we're creating a system here where, for the first time, unions have to compete for members. Some of them will do a good job, and they will maintain most of their membership. There's some unions in other parts of the country that are, just terrible. They're not doing anything for their members. The members hate the union, and the minute they can get away from the union, they're going to ditch it, and the union is just going to go out of existence. So between those two extremes, is what's likely to happen. In California, right now there are roughly 10%, according to the information we have, teachers who opt out of the political portion of the dues. They're agency fee payers. So that is a good measure, possibly, of the number of teachers that will opt out of the full package of dues. So what we think we're talking about are a minority of teachers who disagree fundamentally with the union and don't want to pay any of their, any of the dues, any of their money to the union. It could be more than that, it could be less than that, but that's a good starting point for thinking about what the effect might be.
Yeah, I would just say, the earth isn't going to, go out of orbit or anything, but there will be change. CTA will just not have the money to do what it does. I mean, I can't tell you all the political ramifications, but they just won't be as powerful as an entity. They won't be able to buy and sell legislators the way they do now. So, certainly.
And I really appreciate all the comments here. My name is Mike Jan. I had the honor of serving as mayor of Redondo Beach for 8 years, and we had worked with the unions. And during the recession in particular, we had a choice of laying off people or asking for salary cuts, and we got the cuts, and we got the pension benefit cuts, and it saved our employees. But, I think what Ms. Bhakta said speaks to local control and the importance of local control. And so much of what governs education these days, it seems like, is the state government and the state legislature. So, I think, both of these cases are critical, and I hope they, were successful. But the point is, how can we, with the CTA infrastructure that's in there now, how can we start to reshape that so that places like the Arcadia School District, more of those types of individuals like yourself can start to bubble up, if you will, in the organizational structure of CTA, let's say, and provide that opposing view, if you will, or that alternative view as well. I mean, is there a mechanism by which Arcadia can join, perhaps this organization, or have word spread about changing the leadership?
That's a great question, and I know there's organizations here, Educators for Excellence and Teach Plus, who do exactly this, Teachers for New Unionism. They're out there, and they have a good constituency. In Arcadia, the way this came about was a group of teachers, long before I got there, decided that they were tired of what was happening and how the union meetings went after every faculty meeting, and I think 12 of them together decided we're all going to run and change the face of this. I work at a high school. We have 170 staff members, and before I came, when typically union meetings happen after the faculty meeting's over, and we have our faculty meeting in a lecture hall, and it seats 170 people. When they say, okay, we're going to have our union meeting, there's all but 7 left in there. So the bulk of the people decide to leave and not take part in what our union reps discussed. This was before I got there. Now, because of who's in place and on the board and the decision that they made to run together, people who like-minded that weren't just going to preserve status quo and have meaningful conversations to elevate us, they ran at the same time, and they I don't want to say took over, but they won, and they reflect the majority of we have about 350 teachers in our district, and they reflect the majority, which is why we've made strides with our collective bargaining, and there's such a cohesive relationship with our district office and the teachers, and there's still the teachers who will call CTA for every minor infraction. They still exist, but they're completely ostracized, versus in the majority of California, it's the other way. It's those teachers that will call CTA and make a big deal out of minor infractions and try to protect the most ineffective teacher on campus. They're our minority now, and it's very blissful to be in this kind of place where we are elevating ourselves and having meaningful conversations. And I think it started, I want to say 16, 17 years ago when these guys decided to run together.
Okay, are there any other questions? Lisa?
Yeah, I have a question for Mr. Pell. So you talked a little bit, could you talk a little bit more about the second option of your lawsuit? And in some ways, do you think the unions are more fearful of having the burden of asking people to contribute union dues rather than that being automatic, right? That's what would happen is
right.
You would have to ask teachers to contribute rather than just them asking to not contribute, right?
Yeah.
And with the first part, it would still stand that they would have to ask to not contribute. And which do you think would have more long-term implications, or what would be the difference?
Well, from our point of view, what we're really looking for is the First Amendment ruling that the teacher's not obligated to pay any part of the dues. That is the sort of fundamental big step forward that we're asking for. The opt-in versus opt-out issue, it's an important issue. It's a principled issue. We think that First Amendment supports our view on this. But it's less significant possibly down the road than allowing teachers to opt out entirely. And interestingly, that second part of our lawsuit really has not gotten a lot of attention by the unions or by anybody really. People are really focusing on the first part because that's the new thing. So I'm not sure how the union will react if they have to deal with the opt-in rather than opt-out.
Do we have any other questions?
I have a question for Ms. Bhakta. How do you keep abreast of education issues that are coming in front of the legislature?
I was very fortunate to work with Michelle Rhee and Students First in Sacramento, and so her organization, there's a fellowship program, and once I just became a part of them, I knew about everything that I didn't get through my union meetings. So it was me seeking it out, really. I wasn't researching anything. I didn't do anything brilliant. I became a member of this organization, and that's how I brought all these issues to my union meetings and things that we never received from CTA. That's how we.
So then, if we were to search on the Students First website, how could a lay person who was not part of that program be able to stay informed? I mean, there's got to be, like I receive emails from family groups who tell me, what kind of legislation is going on that affects the family. There's got to be some kind of group that talks about legislation about public education.
There's many organizations that do that. Some of the ones I just mentioned, Teach Plus or Educators for Excellence. I mean, even Pell, Julie's organization, which is a parent organization. There's so many, and they're all connected. We kind of all see each other at the same event, so we all, we have access to the same pieces of legislation and what's happening in the legislature, just because we're all connected. And I do think at the beginning when I first started, I did have to seek it out. When I didn't know, and I felt isolated in my school district, until I started with Students First and met so many people from different organizations that put this out there. It's just, I feel like it's hidden because you'll never hear it at your not your faculty meeting, your union meeting. Right. They won't publicize that. So it is, you follow Teach Plus on Twitter or on Facebook. You follow Educators for Excellence, PALS, those types of organizations where that's all that comes up in my feeds, or those are the emails. I read all of Julie's emails, and sometimes I find out because of her email what legislation is, so I think it's that. Larry's connected too. Larry,
And there's also a great site called EdSource, which you should sign up with. They'll send you emails. And there's also a group called the California Teachers Empowerment Network, who sends out a monthly newsletter, which covers a lot of what you're talking about.
Well, yeah, but okay.
Okay.
Yeah.
You've got a lot of Google alerts to set up, a lot of email places to sign up with. Yes.
I just have one more question. I was very concerned to hear the connection between the elections and fraud and all that, and I'm very concerned about that in future elections. And I don't know if to Terence or you, Josh, in your cases, will there be any thing brought out about that the unions have just too much power and it's affecting our elections in our country?
Well,
or am I extrapolating that and that's...
No, you're right.
No, certainly the relationship between the unions and the state government is at issue in the Bain case because of the argument that I mentioned that the unions are making in that case. They're arguing that they are a purely private organization and therefore they can make whatever rules they want for teachers and they can't possibly violate the teachers' First Amendment rights because only the government can violate First Amendment rights. And so the connection between the unions and the state government and really showing that what the unions are doing that it is this interrelationship between the state, the way the state has set up the system, what the state allows the unions to do, and the authority that the state has granted on the unions with respect to the teachers is all working together to create this coercion. That is very much a part of the Bain case, and so I expect more of that will come out in the Bain case.
Yeah, we strategically decided not to raise a lot of arguments about union misdeeds because we do not want this suit to be either perceived or in reality be an attack on the unions. What we are defending is the right of a minority of teachers to decide for themselves whether the union is a good deal or not. We don't want the courts or the legislature to make that decision for them, and so we don't want our suit to sort of force the courts to take some position on whether unions are a good thing or this union is a good thing or collective bargaining or anything like that. So that's why we're just leaving all of that aside.
And I should just say, we're in the same position. We're not looking for any court to announce that the unions are bad. In fact, as I mentioned, we have plaintiffs who like their unions and want to be a member. But in some respects, the unions are the ones that have invited the argument that the unions and the state government are sort of operating a joint system that has this coercive result, because they're the ones that are arguing that they're so private that they can't violate our teachers' First Amendment rights. So we have to respond by explaining, no, actually there's this cohesive system going on between the government and the unions and the way that they've set up this arrangement that's causing the problem.
So my question would be, having been given the statistics of 10% approximately of the teachers are opting out of 300 and some odd thousand. It's really good to have those numbers. What I would say is if there are that many teachers unresponsive to 2 cases now happening, how would we get that information out to a layperson? Because I kind of wonder if we would gain some courage or momentum, because it's the taxpayer who we're fighting for, but the taxpayer doesn't know what we're fighting for. And so all of us here, we're shop talking, or shop talking. We all get the language, but we have one breakdown here. Well, how would we encourage the taxpayers to join us and get behind us, because what benefit is it for them? They could hear us as grumbling teachers. You have a job, why are you complaining? You know, if you're in the private sector, I'm just saying things that came my way. If you're in the private sector, you could get fired and they don't have any claim on why they did or not, and they could extrapolate whatever they wanted from you. So how could we get someone, a layperson, to understand our cause and then gain momentum with us? And I think that might empower the teacher to know that they have more than just 10% of the public, of the people fighting with them. Just saying. I could be wrong.
That's a great question. Everybody's looking at everybody else.
Certainly, I think if the Supreme Court rules in favor of the plaintiffs in the Friedrichs case, you will hear it. The public will hear it. The Supreme Court decision has a way of bringing issues to the light of the lay audience, and I think that's part of the value in the case, is that the public will hear about that.
Yeah, I mean, I think one of our strategies has been to have the plaintiffs like Rebecca talk about what this case means, so that it's not, the public doesn't see it as kind of an abstract, First Amendment fight by some Washington organization, but that it actually reflects, the wants and desires and interests of everyday teachers, that some of them they may even know. And so as we get closer to the court, closer to the argument and the decision, we will be, ramping up our public relations efforts to explain what this decision really means, so the public isn't just kind of, mystified by it. And there are a lot of misperceptions, obviously, that we need to counter that the union's putting out there. So I think at least that's what we're doing. And I think once the decision comes down, there's going to be, further issues about, if we win, about its implementation. And so I think there are a lot of opportunities here. As Joshua says, when these cases get before the Supreme Court, there's just this huge spotlight focused on a cluster of issues, and it's a great opportunity to explain to people what these cases are about and what they're not about, and we're using every opportunity we can to do that.
I'd just like to add to that, because I know that there are a lot of teachers in the room today. And so my comment on that, as one teacher to other teachers, don't be afraid. Because one of my favorite quotes by Edmund Burke is, "All is necessary for the propagation of evil is for good men to do nothing." And what's been going on in education is teachers, because of this coercion, have been too terrified to speak up. And I have a friend in the room with me, and she is the only teacher in my entire district who will speak up on my behalf. And even though dozens will take me into a dark room and thank me for what I'm doing. That's troubling. That teachers are so terrified that they can't even speak for themselves and for what's best for their students and what's best for the taxpayers. And those teachers themselves are taxpayers as well, and have children being negatively impacted by decisions made by the teachers union. So my comment to that would be, please educate the teachers in your life. And please think about David and Goliath. Okay, our case is a David and Goliath. David won. He won. And so don't be afraid, speak out, because the unions have billions to get their message out there. They're very effective at getting their message out there. And they will speak against this, and they already are. Someone in my teacher's lounge the other day said, oh, hey, I read a story about you. It was all about what a horrible villain you are. It was in the Teachers Union magazine. And I said, yes, I know I received it. They forced it on me. So I don't know. But it wasn't true. None of it was true. So don't be afraid to speak out. Don't be afraid to educate the people in your life. This is our chance to get the truth out there.
I agree with everything that was said, and I think Terry's right, and I think maybe Josh alluded to this. When this hits the Supreme Court, a lot of people are going to find out about it. And I also, I'm not going to out anybody, of course, but there are a lot of activists in this room. I know who you are. And please, don't let this event stop here. Please bring it with you. Can we have time for one or two more questions, Vicki?
I don't really have a question, but I am an activist, and I have had conversations with teachers at my school. I am an agency payor, and the stumbling block has been the benefits. Once they find out that they're going to lose their disability, they're going to lose their voting power, they're going to lose their maternity leave, they don't want to have a part of being an agency payor. They want to stay in the union. So I think if that lawsuit goes through, I think you're going to see a lot more individuals opting out of politics.
And you do know that if you, what you said is true, but there are certain organizations like the Association of American Educators and Christian Educators that you can join and at least get liability insurance and other kinds of insurance.
Yes.
This is your show.
Oh, okay.
This is your show.
Well, I'll say that their benefits are better.
Yeah, and actually those benefits you can actually do better if you leave the union. So that part of the argument's not good. I mean, I know there are other things that have to be dealt with, but it's not all bad to leave the union and join a real professional educators association.
Going back to the word used over and over, this word coercion. Is that a legal term? Are there other legal actions we can take, like undue influence, extortion, abuse of power? Can you explain what this coercion is?
RICO.
Yeah, tyranny and RICO.
I'm not kidding. You know it.
Coercion is the word that we've used in our case because there is Supreme Court precedent, there are Supreme Court statements that say that the government cannot achieve through direct means, the government cannot achieve through coercion what it is not allowed to achieve directly. So just like a union, just like the government can't punish you for speaking out, it also can't take actions that coerce you into not speaking out. And so that's where the coercion word comes from, and that's why it's so important in our case.
And a lot of the coercion is sort of not official coercion. It just might, teachers might stop talking to you, or you might wind up eating lunch in your room by yourself. That I don't have an easy answer for that. I mean, teachers ask me all the time, what's going to happen if I leave the union? I tell them about liability insurance, but I also say you might be ostracized or something. I have to be honest about it. And that, I think we can do anything about. Other things, other coercive matters, yes, but one-on-one, I don't think we can do anything about that. It's just a case of being brave and stepping up.
Is Bain's applicability going to be very narrowly on California, the state of California, what happens in this state, or what are the sort of the broader strokes if it does advance up?
Well, assuming it goes up, beyond the trial level, it goes to the Ninth Circuit. The Ninth Circuit is a federal court that governs the entire western part of the United States. If it goes up beyond that to the U.S. Supreme Court, then it would govern the entire country, just like the Friedrichs case. But the goal of the case is to get the courts to declare that it's unconstitutional anywhere in the country for public employees to be, just as it's unconstitutional to force teachers by law to contribute money they don't want to contribute, which is what's at issue in the Friedrichs case. It's also unconstitutional for teachers to be pressured through these types of benefit programs and voting rights, pressured into funding speech that they don't want to speech. So it's a different level of, it's not, as I said, it's not forcing it, it's coercion. And that's the national implication.
Okay, I want to thank you all for being here. We're out of time. It's a very quick 2 hours. And I really, really appreciate your showing up. And as I said earlier, please spread the word about these cases, talk about them. If you hear people going off the deep end, then please set them straight. Hopefully our panel can hang out for at least a few minutes, so if you want to talk to them one-on-one, please feel free to do that. Grab a cookie before you go. And again, thank you so much.